Take the firearms first and then go to court. We have to do something very decisive. Number one, you can take the guns away immediately from people that you could adjudge easily are mentally ill, like this guy. You know, the police saw that he was the problem. They didn't take any guns away. Now, that could have been policing. I think they should have taken them away anyway, whether they had the right or not. A lot of times, by the time you go to court, it takes so long to go to court to get the due process procedures. I like taking the guns early, like in this crazy man's case that just took place in Florida. But take the guns first, go through due process second.
The gavel fell, echoing through the Supreme Court, a 6-3 decision that reignited America's fiercest debate, the right to keep and bear arms. This wasn't just a legal ruling, it was a cultural flashpoint, instantly polarizing the nation. On one side, millions saw it as a defense of their fundamental liberties. On the other, activists and politicians decried it as a threat to public safety. The media reaction was swift and dramatic, painting a picture of chaos and doom. But beneath the outrage, the real issue was clear. The court refused to reinterpret the Constitution to fit a modern agenda. For gun owners, it was less celebration and more relief, a rare validation in a climate where their rights feel under siege. The ruling affirmed that the Second Amendment is not a suggestion, but a command. The right to self-defense is fundamental, especially when government protection falters. Yet this decision is not the end. It's the start of a new, more intense phase in America's gun rights battle. The 6-3 split mirrors the nation's own divisions, fractured, suspicious, and deeply entrenched. The dissenting justices offered a vision where collective safety trumps individual rights, a vision at odds with the majority's reading of the Constitution. This ruling didn't create the divide. It exposed just how deep it runs. The battle lines are drawn and the stakes have never been higher. The Supreme Court has spoken, but the fight is far from over. How did the Supreme Court become the last line of defense for the Second Amendment? It's the result of decades of deliberate appointments, justices committed to interpreting, not rewriting, the law. The conservative majority, led by Thomas, Alito, and Gorsuch, has transformed the legal landscape, insisting the Second Amendment is a core individual right. Lower courts once treated gun rights as negotiable, but now, every restriction must be justified. No more rubber stamping in the name of public safety. This shift has made the Supreme Court the ultimate backstop for gun owners, forcing lawmakers to think twice before passing new restrictions. Critics call this majority partisan, but for millions, it's a necessary bulwark against laws that punish the law-abiding, while failing to stop criminals. The real battle is now in the courts, with the Supreme Court as the final arbiter. The majority understands, rights are not privileges to be granted or revoked by political wins. The 2022 Isam, the Domberdan, Schaubenanderdian 2 Bruin decision changed everything. It tossed out the old vague balancing test and replaced it with a clear standard history and tradition. Now, any gun law must align with the nation's historical approach to firearm regulation. If a similar law didn't exist in 1791 or 1868, it's likely unconstitutional. This new test strips away judicial guesswork and grounds decisions in the Constitution's original meaning. Judges must now act as historians, not policymakers. For gun control advocates, this is a nightmare. Most modern restrictions have no historical precedent. Bruin has become the central battleground, arming gun rights lawyers and forcing government attorneys to dig for historical justification. The decision was a direct rebuke to decades of judicial activism. The Supreme Court made it clear, the right to keep and bear arms will be measured by the unyielding bedrock of American history. The next major showdown? Age-based gun bans. The Supreme Court is considering whether states can bar 18 to 20-year-olds from buying handguns. These young adults can vote, serve in the military, and sign contracts, yet many are denied the right to self-defense. Gun control advocates cite public safety and brain development. Gun rights supporters call it unconstitutional discrimination. The Bruin standard is key. There's no historical precedent for banning young adults from owning firearms. In fact, they were often required to be armed. If the court takes up this case and applies Bruin, age-based bans may fall. Such a ruling would be a landmark for gun rights and a major blow to the gun control movement. The stakes for young Americans and the nation are enormous. Every Supreme Court decision affirming gun rights triggers a fierce, coordinated backlash. Media and activist groups quickly label the court extremist, painting gun owners as threats to public safety. Calls for court packing and new restrictions flood the airwaves, aiming to delegitimize both the court and ordinary Americans. Law-abiding citizens are conflated with criminals, their rights framed as a public health crisis. This is a campaign of social pressure, designed to isolate gun owners and make them surrender their rights without a fight. Emotional stories dominate the news while defensive gun uses, millions each year, are ignored. Politicians and corporations feel the pressure, and many citizens hesitate to speak up. The goal: create a climate so hostile that gun rights wither away. That's why the Supreme Court's decisions matter. They push back against fear and intimidation. Constitutional rights can't be erased by media narratives or political campaigns. The fight for the Second Amendment is as much about culture as it is about law. While the Supreme Court sets the tone, the fiercest battles are now at the state level, like Oregon's Measure 114. This law requires a permit to buy any firearm and bans magazines over 10 rounds, targeting the most common equipment for self-defense. Supporters claim it's about safety, but critics argue it only burdens the law-abiding, especially in rural areas where police response is slow. Criminals will ignore these laws, leaving citizens at a disadvantage. The legal fight over Measure 114 is a test for the post-Bruen world. Does history support such restrictions? The answer, opponents argue, is no. The outcome will signal whether states can defy the Supreme Court and restrict gun rights. Oregon's battle is a warning and a precedent for the rest of the country. The state-level war is just beginning. Bruen was meant to clarify Second Amendment law, but it's unleashed legal chaos. Lower courts are split. Some strike down gun laws, others twist history to uphold them. The result: a confusing patchwork where what's legal in one state is a felony in another. Millions of gun owners are left uncertain, fearing accidental violations. This confusion is fueled by judges resisting the Supreme Court's clear mandate. That's why the court keeps stepping in. Age bans, drug user restrictions, carry laws, forcing lower courts to follow the Bruen standard. The message, history, and tradition are now the law of the land. The future of the Second Amendment depends on whether this standard is faithfully applied. If not, rights will depend on geography and politics, not the Constitution. The Supreme Court has chosen the Constitution. Now, the nation must decide if it will follow.